In this series of lectures, we would like to start another important concept of law, and that is relating to law of insurance. So, first of all, we would like to discuss the very meaning of insurance. So, it is a contract in which one party, known as the insured, insures with another person known as the insurer, assures or underwriter his property or life or the life of another person in whom he has a pecuniary interest or property in which he is interested or against some risk or liability by paying a sum of money as the premium. Under the contract, the insurer agrees to indemnify the insured against a loss which may accrue to the other on the happening of some event. So the instrument containing the contract to insure is called a policy of insurance. So from the very meaning of insurance, we found certain basic legal requirements of a contract of insurance, and those legal requirements are the one is intention to create legal obligation, and there must be an offer and an unqualified acceptance, and another one is that the parties to the contract competent to make a contract of insurance, and another legal requirement is that it must be free consent of the parties entering into an insurance contract. So there must be a legal object. So first of all, it as it is an agreement, so it involves both offer and acceptance, and there must be a legal consideration, and also the very competency to contract, and the contract must be lawful object, and also there is must be certainty and possibility of performance and free and genuine contract, and in an insurance contract the agreements must fulfill certain legal formalities, such as it must be in writing, complying the necessary legal documents, requirements such as registration, attestation, stamps, etc. So, these are the legal requirements of an insurance contract. And now we'll discuss the requirement of these legal contracts, and as such, the contract of insurance is itself a legal document, and it must be followed by certain principles, and those general principles of insurance, as we found the very principle of indemnity, the principles of good faith and the insurable interest. And another most important principle is that causa proxima and also mitigation or minimization of loss, and also a risk must be attached to the contract of insurance. So also the principles of subrogation and the principles of contribution. So, as regarding the principle of indemnity, contracts of insurance, except life and personal accident insurance, are contracts of indemnity. A typical contract of insurance involves an obligation on the part of the insurer to pay a sum of money to the insured upon the happening of some event. Further, to get a claim from the insurer, the event must result in a pecuniary or monetary loss to the insured. In no case, however, can an insurer recover more than the amount insured. So, in that connection, to clarify exactly the principle of indemnity, would like to discuss an example, and that is, suppose A insures his motorbike against accident and theft for rupees 1 lakh. The motorbike meets with an accident and the loss thereby occasioned is Rs 10,000. So the amount recoverable from the insurance company will be Rs 10,000 only. And in case the motorbike is stolen, thus resulting in a total loss, the amount recoverable from the insurance company shall be Rs 1 lakh. Thus, the insured is not permitted to make a profit of his loss. If the insured is permitted to receive a sum higher than the amount of loss which he suffers, he would be tempted to destroy his goods intentionally with view to make profit out of the insurance. So, regarding the very principle of indemnity, we would like to discuss the very important leading case that we have chosen exactly the very important leading case relating to the principle of indemnity as applied to the contract of insurance, and that particular leading case that we would like to discuss is Castellian versus Preston. So, exactly what it was determined that all contract of insurance except life insurance are contracts of indemnity also indirect relationship between principle of indemnity and principle of insurance interest is involved and established. And also indemnity amount never exceed the actual loss. Also, after compensation payment, the principle of subrogation is applied in case of the contract of indemnity. So also, valued policies not concerned. So exactly, valued policies except marine policies are not covered under the scope of principles of indemnity. And in that regard, would like to discuss another important leading case. And the second important leading case that we would like to discuss a case of 2015, and that is Ridgecrest, New Zealand Limited versus IAG New Zealand Limited, and it was decided by the New Zealand Supreme Court in 2015. So, exactly, the Supreme Court found and decided which would have that the decision will likely not have general application to all the claims as it is specific to the policy wording in this particular case. And that is that indemnity principle applies and cover for partial damage from earlier as it was relating to damages caused due to earthquakes is indemnified the basis, not a replacement as new for old basis. So this is of the contract of indemnity as decided by the Supreme Court of New Zealand. So the very decision of the Supreme Court as it determined redress is entitled to be paid in respect of the damage caused by the earlier earthquakes up to the sum insured for each earthquake, as well as the sum insured in respect of the final earthquake. However, for damage caused by earlier earthquakes, Ristad was not was entitled to a payment on indemnity rather than replacement for damage sustained in each earthquake. So, this is the first general principle involved in an contract of insurance. And now we'll go to the second important principle that involved is regarding good faith. So, the very principle of good faith is otherwise that there must be utmost good faith and frankness between the insured and the insurer. The insured is under an obligation to make the fullest disclosure of all such facts which may have some bearing on the decision of the insurer to enter into such contracts. The withholding of any relevant information or misstatement of any material fact may give the insurer the legal ground to declare the contract void. Therefore, all contracts of insurance are contracts of utmost good faith, and therefore non disclosure of a material fact entitles the other party to avoid the contract. Whether the fact not disclosed is material is a question of fact in each case. So, in that regard, we would also discuss that non disclosure of the facts and materials and also concealment of any such fact by the either the insurer or the insured would invalidate an insurance contract. So, in that connection, we would like to discuss one example, and that also decided by a leading case. As for the example, we said in the very leading case of London Assurance Company versus Mansell, decided by the Chancellor Division, where an applicant for an insurance policy, when asked whether he had applied to any other company for insurance and whether such application was accepted, replied that he was insured with two companies but concealed the fact that his application was rejected by several others. It was held in this important leading case that there was material concealment. Therefore, the policy was set aside, and in that connection, we would like to discuss another important leading case, and that is the Associated Oil Carriers Limited versus the Union Society of Canton Limited. In 1971, the King's Bench held that the nationality of the insured was cancelled at a time when his nationality was important. So it was held to be the non-disclosure of a material fact by the insured. So, a new material fact which arises at any time during negotiation, or a fact which, though earlier not material becomes material owing to change of circumstances must be disclosed as soon as the insured comes to know it, as where there is refusal by other insurers to renew an existing policy, the duty of disclosure, however, refusal by other insurance to renew an existing policy. So, it is the duty of to disclose which exists only up till the conclusion of the contract and therefore comes to an end when the contract is complete. And in that connection also would like to discuss some other important leading cases which are relating to good faith as such. The very important leading case that we would like to discuss is relating to the track why securities and finance private limited and versus national insurance company. So in that particular case, as we found, which was decided in 2004 as regarding the very insurance relating to Indian Marine Insurance Act of 1963 and the very section 19 of the act was involved. So the very case was decided on 2006. So as exactly on relying the said judgment, we found that it was declared in the judgment that utmost good faith requires each party to tell the other the truth, the whole truth, and nothing but the truth about the proposed contract. It is the duty of both insured and insurer to reveal the facts and other information and maintain the trust between each other. In one of the cases, as we were discussing, the marine insurance case where the insurer knew that the vessel proposed for insurance had in fact already sunk unknown to the owner. Withholding this information was to be a breach of utmost good faith. And also, in that context, would like to discuss another important leading case decided in 2015, and that is Focrati versus CGU Insurance, and where it was the very fact regarding the case is that Focrati had a policy with CGU Insurance that insured her residents against accidental loss or damage. It was in 2009 there was a fire in the kitchen of the premises, and Fogarty made a claim on our policy. This CGU insurance accepted the claim and elected to repair the damage, proposing to replace the three damaged floor wood sand, re-sand and re-seal of the entire kitchen floor. However, Watty was concerned that the re-sanding would cause the kitchen floor fail because it had been sanded previously and was wearing thin. She then pressured the CGU insurance to accept responsibility for replacing the whole floor in the event that the sanding caused failure. And the CGU insurance company refused to accept that responsibility. So, this is the very fact in relation to this leading case. And as regarded the very decision, the policy provided coverage for loss or damage as a result of a fire or caused by a defect, structural defect, or faulty workmanship. Also, the policy also stipulated that the insurer would decide whether the claim would be settled by repair, rebuilding, or payment to the insured of the cost of repair or rebuilding. The original installation of the timber floor in the kitchen was defective in several respects, which Fogarty of insurance were not aware of prior to the fire. So the key lesson that we derived from this particular important leading case, as an insurer won't breach the duty of utmost good faith if they refuse to agree to fulfill an obligation that is not otherwise named in the policy. So we have discussed the first two most important principles, which are the general principles involved in all insurance contract, and as such we would like to discuss the next general principles involving insurance contract in our next upcoming lecture.